That would have been good.
We are live.
All right, welcome back to the House Judiciary Committee this Tuesday afternoon, March, I think I've been saying February this morning, wasn't it? March 10th. And we're going to now look at H629. And we have, it's a two-page bill. It's not the as introduced, it's one that has some slight changes to the language, and we'll have a walkthrough by Michelle. Thank you for being here, Michelle.
Thank you. So for the record, Michelle Childs, Office of Legislative Counsel. And I'm just going to give you a quick little overview of this because you've got some great witnesses that are much more knowledgeable and practicing specifically in this area, and the proposal came from them. But just a little kind of set the stage here. So we're talking about statute of limitations, and you guys have actually worked a lot on statute of limitations this year, right? On some earlier bills. So we know that judgments aren't forever, right? So if a judgment is not renewed before the statute of limitations expires, then the debtor no longer is legally obligated to pay back or make amends to the creditor. Statute of limitations are there to make sure that that there's legal certainty for the litigants, to prevent the enforcement of like stale claims, and protect defendants from essentially not, having these things like the specter of litigation going on forever. So Vermont has a statute of limitations which applies to judgments. So we're looking in Title 12 in court procedure. This is not usually, I've been working more in Title 12 this year than I ever have actually in all my years here. So usually Eric works on these, but we're doing a little bit of divvying up. And since I do typically do family law, I'm working on this one. So there, you'll see in the language that you have, it's amending Title 12, Section 506, and this has to do with statute of limitations on judgments. And you'll see there that actions on judgments and actions for the renewal or revival of a judgment have to be brought. And you'll see the new language just clarifying that it's brought in the Civil Division of the Superior Court by filing a new and independent action on the judgment within 8 years after the rendition of the judgment. So there's an 8-year statute of limitations. Remember, kind of the general default is 6 years for in civil litigation. But this is 8 years. So essentially, if you do not file for a renewal of the judgment within 8 years, then it's done, right? I want to note, and I think probably some of the witnesses might mention it, is that, so this section, 12 VSA 506 was amended, I think in 2010. For those of you who were here then, you might, not really?
11 for me.
Yeah.
I think it was 2010 to double check, but there was it was when Maxine was chair, and there was a bill on mediation and foreclosure proceedings. And so in that bill, there was kind of buried down a little bit there was a change to this section on Section 506 that required, and I have a copy of that, and I can send it to Nate if anybody wants a link or whatever, but there was a provision in Section 8 that amended it by requiring this new filing of a new and independent action on the judgment. So that was kind of, somewhat new, right? And so there was a court decision in 2020, Blake v. Petrie, not quite sure how to say that. Petrie, okay. And they were considering this issue around how family court judgments work with 506. And I think the witnesses can talk to you about how family practitioners have been operating under the family rules for basically enforcement of a judgment. So thinking about some judgment for money or for property, things like that. And essentially the court said that for these family court decisions that they fall under this provision of subsection A, and there had to be a new independent action filed, right? So what that essentially does is it means that, let's say you're in family court, in divorce proceedings, you're figuring out child support and parental rights and responsibilities and all this other stuff. And then under this, and the interpretation of the court is you have to go over here to civil division to deal with if you have to renew a judgment for money or for property, which you can understand, and I think the witnesses will talk to you about why that isn't necessarily in the best interest of litigants, especially because when you're in the family division, you're dealing with a lot of pro se litigants, and why not have everything in one division? And I'll actually, because I always really like when, the court speaks directly to you and says, hey, do you guys want to take a look at this? Justice Robinson wrote a concurrence in that case, and I did provide the link to Nate, so I think it's up on your website. And I'm just going to read that, is that application of the requirement to divorce orders gives rise to unnecessary confusion and costs for divorce litigants who may be forced to simultaneously litigate some post-judgment issues in the family division and others in the civil division. And it imposes additional burdens on the court system. Amending 506 so that a motion to enforce a property judgment in the family division pursuant to the family rules can serve to renew the judgment for purposes of the statute and would not undermine the goals of the statute. For these reasons, I urge the legislature to revisit this statute. So I think that's why folks are here today asking for these changes. So looking at the language that you have, and the highlighted language just shows little tweaks that were recommended, again, by the folks who were working on this with the VBA that were not in the bill as introduced, but things are moving fast this week. So I wanted to get you this language now for your consideration rather than them propose it and me have to do a new draft and come back another day. So if you see subsection A is just the existing language, just clarifying, adding in there that that it's in the civil division of Superior Court. Then B is the notwithstanding A. And so that says for that the family division has exclusive jurisdiction over actions on judgments that are issued by the family division. And then you have a number of subdivisions there that provide some framework and detail for that. Subdivision 1 provides that for judgments for money or property, but that does not include any orders or awards that convey real estate because they would have no statute of limitations. But for judgments on money or property, renewal of a judgment has to be made by motion to renew in the county that issued the underlying judgment within 8 years of rendition of the judgment, which means like the court issuing their decision. Or when the last payment or action required was due, whichever is later. And then it provides also in there that the motion is to be served in the same manner as prescribed for the filing of a new divorce action or a parentage action that's provided already in the family court rules. And I can provide, if folks are interested in that, I can provide a link for Nate. Subdivision 2 provides that once a motion to renew is filed, tolling of the statute of limitations is paused while the court is considering the motion. So pauses it while the court is thinking about it and looking to issue a decision on that. Subdivision 3 lists various actions that would automatically restart the statute of limitations. So you'll see there under subdivision 3, things like a written signed acknowledgement of the debt, action, or obligation ordered in the judgment, any payment made by an obligor or a family division judgment, including wage withholding, any affirmation action taken by an obligor towards compliance with the provisions of that original judgment, and any payment made by a third party on behalf of the obligor being the person who was required by the judgment to be paying the other party. And then subdivision 4, sometimes you'll see this and we'll have it in statute where you feel like it's really important that litigants are aware of certain, consequences. And so this is just something that would be required on any property or money judgments that are issued by the family division, is just a statement of what this section is doing, which is that a renewal of a family division judgment for money or property has to be renewed within 8 years, or when the last payment or action required is due, whichever occurs last.
All right. Questions?
Where did I think you said earlier where this language came from?
The Vermont Bar Association.
We can hear some of the folks who are working on it.
And some folks, maybe, I don't know, maybe Bob remembers the mediation on foreclosure. And whether they talked about that. I asked Eric, because Eric staffed that bill, but he's like, I did. So,
So is this an unusual provision? Like, do other states do this kind of thing?
I don't know.
Yeah,
I mean, I think, again, the witnesses can, who are practicing this could tell you. I mean, I would just say, I haven't heard in looking at this and reading about this, any particular policy reason why you would have certain judgments happening in family division and others happening in the civil division. It seems like, why wouldn't you, for the benefit of the
Judging.
court?
Judging from some body language over here, somebody may have an answer to that.
Okay. But it seems as though it's most expedient and efficient for everybody, perhaps to have everything in one place.
right. It's like one of those, like, okay, is there a onion we're unpeeling that's gonna do
Right.
some weird? We'll find out.
All right, so thank you. Thank you very much, Michelle. Jim, Matt, if you could join us again.
Think about that, please. Yeah. So,
Good to see you back.
thank you. I'm still James Knapp. I still go by Jim. I have never been in court. I most certainly have never been in court related to family matters. But I'm here because of one clause that was added at our request, which was to be sure it was absolutely clear to everyone, without question, that a judgment that effectively conveys real estate is not subject to any statute of limitations. Bear in mind that in many family court cases, there will be a provision in the order that says family residence to spouse one, spouse two to get $25,000 when the residence is sold. When this whole statute of limitations issue was brought to my attention, it occurred to me that someone might think if they don't do something every 8 years, they're going to lose title to their house. Or more likely, someone's going to think, hey, my spouse didn't do anything about this for 10 years, so now I own the house again. We don't want any confusion. So you put in the 1 9-word clause that I'm here to say is a really good idea, and I have nothing further to add to this bill. You did mention this morning that you wanted me to comment on section 27 of
The
miscellaneous judiciary bill.
Got to have you on that earlier.
So putting on the other hat, so to speak, that provision reflects a change that your predecessors fixed. I was trying to think back. The 2 words that are being removed are sealed and witnessed as they relate to the assignment of a lease by a deed. Nobody signs leases by deeds anymore. No one probably even knew this statute existed back when you did 2 things. I believe that you removed the requirement for a seal on a legal document in the 1960s. And the only reason I know that was because one of my other jobs besides hand copying title abstracts was to run to Shattuck's stationery store and buy the little boxes of legal seals that were required in a law office. And then in 2004, your predecessors removed the requirement for witnesses on real estate documents. And so this is a mere technical correction to bring this statute, which no one has looked at in years, into compliance with all the other statutes. And with that, I'm done.
Great, thank you. Thank you very much, Jim. And we'll go to Leslie Black next. Or you can pick who wants to go first.
We figured that Dan will go first.
Okay. Okay, all right, excellent. Thank you for being here.
Thank you, Chair Lamont. My name is Amber Barber. I appreciate everybody here at the committee for all your work and for taking some time to hear from us. I am a family law practitioner in Burlington, Vermont, and I've been practicing in Vermont for over 28 years now. It's all I do is family law. I've also been the past chair of the family law section of the Vermont Bar Association, as well as the past president of the Vermont Bar Association. And I'm here today because I want to try to explain a little bit about why family law practitioners and the VBA really believe that it's important to make some changes to 506. First, I want to mention, and I want to go back to what Michelle Childs said about the benefits to the pro se self-represented litigants in family court. It's very important to provide access to justice to those individuals who really struggle to get through the judicial process. And for them to come into family court is already a very significant challenge for them. But then to have them have to try to understand that they have to go to yet another court every 8 years to renew their judgment is just adding layer upon layer of confusion and difficulty for those individuals who we really need to help in the situation. I think the other thing I want to mention is it's confusing. It's been confusing to even us, the practitioners who've been doing this for years. Before Blake v. Petrie came down, there wasn't a practitioner that I know of in Vermont in family court who didn't march into family court and enforce these orders. That was the historical practice. And so this changed it. This completely changed the dynamic. It changed how we look at all of these particular orders that we're trying to ask to be put in place. But it also changes the dynamic of how do we enforce these things. Parties in a divorce are in a fiduciary relationship coming out of it. A lot of these people have been married for many, many, many years. And when we unwrap their lives, it's not an easy unwrap, right? I mean, sometimes it's a house, sometimes it's paying something for a retirement, whatever it is, there's a lot of unwrapping that goes on. And those things can't be done in short intervals sometimes. So to make individuals who are actually paying and doing what they're supposed to do have to come in and to file motions to renew or enforcements, it's just placing much more strain and stress on the judiciary, right? The cost of these extra motions and motions to renew, it's placing burdens on civil court to all of a sudden take on family court actions, and then it's placing issues on the family court for having to renew things that really don't need to be renewed if someone's paying, right? If someone's actually doing what they're supposed to do, why do we need to place a difficult situation on someone? And I think that's the issue with, what Blake v. Petrie says is, yep, you have to go to Superior Court or you lose your opportunity to enforce this judgment. And the second case that has come down in 2022, which is Trod v. Trod, went on to say, well, there's one little exception to it, and that's in the common law. If you acknowledge the debt in writing, then there's these exceptions. But the exception is so hard to fulfill, and there's still this complex, how should I say, discord between what does that mean? When is this renewed, right? Is it renewed at going back to the initial order, or is it renewed at the enforced judgment? When does it renew? So I think what we're trying to do is make this less confusing for everybody, more cost effective on the courts for the burdens, and also remove any simultaneous litigation that might have to go on. I'm happy to answer any questions you may have about this bill, proposed bill.
Yeah, I was just looking to see if you had submitted those two cases. And if you could do that to Nate, so we have that as part of the record, I appreciate that.
You have the one. I didn't give you the second.
Oh, okay, all right. So yeah, that's second.
Second.
You want to just send that to me? So you don't have to look.
Okay. Thank you.
So questions for Amber? seems straightforward enough.
Yeah.
So I appreciate the example that you gave as far. I was trying to get a context for this when we gave the example of both with divorce and such. That's helpful. No other questions? So we'll go to Leslie.
Thank you.
Thank you very much. And I guess the question I should have asked for everybody is whether there's been opposition to this and where would such opposition come from? It doesn't, when I read through it, I don't understand why or where it would come from, except for Jim, if you didn't put the real estate component in
We were happy to do that for him.
there.
I'm Leslie Black. I've been a family court and other attorney, meaning I do other things as well, for, I hate to admit this, but over 45 years. And I have seen through my practice for a very long time, the way family court orders have always been done. And what Amber mentioned is we have always gone back into court to the family division to enforce our court orders and without any cap in time. So you have court orders coming out of divorce court, for example, that say the plaintiff is awarded possession of the house and can stay there until the last child turns 18 so they can finish school in this town. Okay, but one of the children is 4. You can do the math. It's more than 8 years. If we have an order required to renew a judgment and they know nothing about it, which is where we're finding pro se litigants to be, unfortunately, what happens when a person stays in the house and the confusion of how you enforce it is just awful and it's ambiguous. So we need something fixing the ambiguity. That's the real crux. This thing tries to clarify that if you're in doubt, you go there. It's very clear. You go back to family court, and the language at the end of this bill is really similar to the language we now have already on our court orders. We already have language in our court orders trying to tell people, pay attention, it's in caps. Unfortunately, real people in the midst of emotional distress, which is what we do, they might read this, but don't think that they absorb it. And who's going to remember where they put their court order in 7 3/4 years to run back to renew? If at least if it's in the family division, they can check in and say, something's happening. But there's another aspect to this that's very crucial, and that is we don't want a bill where we're required to go and renew a judgment in 8 years. We want a bill that says, if you haven't done what you're supposed to do, that's when the time starts going. Why would we renew a judgment for the house move from one person to the other when the time hasn't lapsed yet? You see what I'm saying? So it's just not sensible. This makes everything easy to follow, more sensible. Family court attorneys won't have the ambiguity of the 2 cases that came down, which quite frankly, if a court case says it's exempt from the statute if you've confirmed in writing that you owe the money, it's confusing to me as a family court attorney because any divorce I've done where we reached a stipulation has a contract between the people admitting that they owe the money. Is that becoming meaningless? And if you go and you enforce a court order within the 8 years, does that mean that we're enforcing that judgment another 8 years? It's just too confusing. This thing really simplifies it. It basically says from the time that it's owed to be done, that's when the 8 years runs. And you go back to family court where you started, and you don't have to go here for custody and there for money. It's all in one place.
So can I ask a question on, I'm looking at, do you have the language in front of you? Can you
I almost have it memorized. Yeah.
So my question is, I'm looking at line 14, as far as this is when the 8 years after rendition of the judgment, I understand that, or when the last payment or action required is due. Could you just explain that second part, the when the last payment or action required is due? I want to make sure I understood.
Yes, I would be very happy to explain that to you. If you have a court order and one person keeps the house and the other person is paying a buyout, but they don't have the money, which we find a lot. And we do a payment plan and they're paying monthly for 9 years. And they're paying. And then 8.5 years later, they stop paying. That's when the statute of limitations starts running, so that you didn't have to run in and renew when everything was copacetic and there was no need. And it just ensures that the person who's owed the money isn't foreclosed from going after getting that thing done when the person knows they're supposed to be paying.
I guess, is that then clear? Because it seems to me that it's, what you're saying is when the last payment or action required is due and actually not paid, you know, that the action isn't taken and the payment isn't made. Isn't that?
Well, if the payment is due in 9 years and they don't make that payment, that statute of limitations runs from when that last payment was due, not from when the judgment was issued by the family court.
Right,
That's the difference.
right. No, I understand, but it's
Okay.
just the language doesn't say.
Well, it basically,
They missed the payment, that last payment, is I guess what I would just.
well, I think it's saying something broader and it's done on purpose. It's not even saying if you don't do it. What it's saying is if we have to have a statute of limitations and it's going to be 8 years, let's let it run either from the date that the court order is issued, or in the event that the court order says you're supposed to do something, let it start from then.
Right.
It's a safety feature.
Gotcha.
For me, it's a safety feature to protect my clients who are owed the money, really.
Understood, then now, thank you for clarifying.
Okay, sorry for the confusion.
Hi there. I
Hi.
have two questions. One is at the very end of the proposal. You think that the word, I'm looking at the language for, you know, the all caps language. And I'm wondering if time barred is typically understood by your clients. Should we look for a more plain language phrase there? I know it's not super complex, but it's not commonly used.
You know, it's really hard to do this, Bill, a little bit. Having not done this before, and it's interesting because we just added in to that language, which the newer language that you're seeing is, or when the last payment or action required is due, which had been missing. You could say or shall be foreclosed, but, you know, then they start using what's real.
Closure sounds like closure. Yeah, I don't know. I mean, I'm just imagining a person, like you said, in a very.
I mean, I could even say, you know, you could say moot because people watch TV and they always mispronounce it, but I don't think it's a good idea to do that either. Time barred.
You're saying that it's, or it shall be, you know, limited to the statute of limitations, right? I mean, limited by the statute of limitations.
Or it cannot be enforced. Would be easier language, very easy,
Yeah.
easily understood, and I think I would recommend that.
So whichever occurs last, or it cannot be enforced.
Correct, correct. I'm trying to make it so everybody can understand it, really. We all have been. We've been throwing this language around and, you know, within the response to the Supreme Court judgments, which really upended how we did practice, and then how to do it and how to make it so that people will understand. I mean, I would have to say to my client at the end of the case, I want you to look at this language. I want you to understand what we're talking about. This is extremely important. You know, don't lose the judgment. Don't forget. You know, people retire. People move away. It's problematic.
Yeah. And then my second question, which has to do with the first part of the bill, and I may have missed this, I was otherwise occupied at the beginning of Michelle's walkthrough.
Okay.
Why is the renewal required every 8 years?
The Supreme Court judgment basically said your family court orders are not special. They're not in another bracket. you have to go and renew them just like every other civil judgment. That was what we didn't expect to happen. So if we said there's no statute of limitations on family court orders, that would be the end of it. But within the context of what happened through the Supreme Court and the evolution of this was
This is
the best case scenario, given that it wasn't how we wanted it in the original.
That seems really out of touch with the reality of family situations, and
I'm not supposed to say anything.
I can say that.
I'm trying not to. Can you read my face? Here.
Ian, did you have a question?
I have a question, but it's probably for Michelle. I'm just wondering, as far as draft or like, when we're looking at drafting statutes and we put exact language in like this, like saying that any judgment has to have like this exact language.
Yeah.
Someone like misspells a word in it or something, like when a court is ordering a judgment and if they don't put this language in exactly, could that impact like the validity of the judgment? And if so, is there anything that we can do to put something in here just to say like it should, to the effect, say this or something like that?
I don't know the answer to that question, but I bet Judge Sylvie does properly your declaration.
Okay.
Yeah,
I think it's a Scrivener's error.
Yeah.
And I don't think that if you have everything here and you misspell the word property, that it's going to void the order. I don't think so.
Yeah. Fair enough. Yeah.
And not for nothing, but the forms are on the judiciary website that we print out that are fillable. The pro se's use the forms, and I have found mistakes on occasion and let people know, so they fix them. I mean, seriously, it's only humans.
Yeah.
So you let them know and they fix the form and then
Yeah.
it's done. So I understand your question.
Yeah. And I think it's even more like, I'm kind of curious because we've seen this in a couple other things that we've looked at where just when we're telling someone that this exact language needs to be in the order or in your motion, or if that kind of error.
You have it in criminal orders too. I mean, you have certain things in criminal orders that have to say certain things with notice. It's notice, basically.
Yeah, I don't know if it says
I think that's the issue, is that, you have a misspelled word or you miss a punctuation or something like that, but are you conveying the proper notice that's required by the statute, and to just say that because you misspelled a word or something like that, and therefore you don't, you missed your chance, it seems kind of an absurd interpretation of the statute and the legislative intent.
Yeah, no, I was, because of, yeah. I don't think that-
That's a great question.
No, I think it's
I think it's different in family court than in criminal divisions,
gonna be.
by the way. Because criminal specific.
What's that?
Criminal would be different because it's
No.
so specific.
We're gonna
It has
find
to
out.
be
Specific, yeah,
And this is a little bit more
More.
forgiving, yeah.
yeah.
I think that's probably good. I have a question for somebody, and maybe it's Bob, I don't know who. Is there opposition to this? Has this been put out there to
It was put out.
uncover opposition?
It was put out to the listserv, and there isn't any that we got no negative. In fact, I think we got somebody who made a comment and we changed the language to incorporate it because it was a good idea. That's all we've had.
Well, I think I have 2 minutes till my next witness, so I'll ask you one more, you have to answer in 2 minutes. So I'm just looking at, on the page, on the second page, B3. Well, maybe I won't ask the question because I just, I'll ask anyway. Any of the following shall restart the statutory limitations subdivision 1 in the subsection. Can you just kind of give me a general sense of why those are the triggering factors for restarting the statute of limitations?
Yes, we basically wanted, okay, so A is specifically because of the Trout case. And that was the language from the Supreme Court, so we wanted to incorporate it, make it very clear that we knew about that, and we were doing it in full knowledge. B, C, and D are all done based on the same philosophical situation we were talking about earlier, which was, if something isn't due, there isn't a breach yet, So the statute of limitations could run from that outside time, for example. So if you make a payment, then the statute of limitations is going to start after that because you're in compliance, for example. And if they're all the same in essence, but they're all from different directions. So
Right.
if somebody makes a payment on your behalf, then you've been paying all along. There is no breach. Until, you see what I'm saying? There's no breach
No,
here.
I understand. No, but I needed that clarification, so thank you.
They were all from different directions.
Yeah. no,
Tried to
that's great.
cover everything we could see people doing.
Everything's nice, and once it, you want to have, yeah.
Yes, and because people are in this situation now, and our situation is so ambiguous after the court cases, the sooner we get this fixed, we feel the better.
Perfect. I appreciate it. Thank you very much for being here. So look at that, right on time, Will. Like we were, this doesn't happen very often. If you can join us.
So ask a quick question.
Yes,
So
go.
I made the small change to subdivision B here. So that it will be, or it shall be, or it cannot be enforced. Do I send that to Eric? There's no.
So
We'll just kind of hold for now.
Actually, we'll have, I mean, where's the rest of the committee? Is it something that we're fine with putting on? It doesn't seem controversial to me. Seems fairly straightforward. Are we fine with putting it onto the miscellaneous bill? And we'll still have additional testimony because I still need Judge Zone.
Other than loath, presenting the fact that I have to legitimize this 8-year thing.
It's there in here.
I understand your feelings.
Yeah.
So no objection to putting it on. Yeah, you can send it to Eric.
Send it to Eric and ask him
Yeah.
to.
Yeah, please do. And we'll just have Judge Zone, and if he finds huge problems with it, we'll just take it out.
We
All
can
right.
come back next year with an amendment.
Thank you very much. Thank you, Jim. Thank you. All right, over to you. Thank you for your flexibility, and I apologize for not having put you on the list somehow. I don't know how that happened, but.
Happy to be here. Willa Farrell, Court Diversion Pre-Trust Services Director with the Attorney General's Office. Would you like me just to explain why I suggested these?
Yeah. We'll go over each of them that you're involved in. I guess I do want to just ask, I didn't have you down for the moving of the language that's in section 1. I know that's not really part of diversion, but it is language related to the Attorney General's office. Should I ask somebody else from the Attorney General's office to weigh in on that one, Mike Todd?
Yeah.
Okay.
I believe Todd is in the building. If you want, I could see if he's.
Fine. No, you can proceed with the parts that are yours.
So the first suggestion that I sent to Eric was on page 4. So this is stemming from last year's legislation where you added 0.02 violations, sometimes called juvenile DUI, to the statute that deals with possession, consumption of alcohol by youth under 21. And in the act, so in current law, if an individual who is goes through the program where a 0.02 violation, after that, their license, driver's license, which is suspended for a certain amount of time, is automatically reinstated by the Department of Motor Vehicles, meaning they don't have to pay I think it's $82 reinstatement fee at this point. However, in current law, that is not true for individuals who fail YSAS for simply possession of alcohol or consumption. So the suggestion is to make that an equitable benefit regardless of the violation for which you go through. So the I'm not always accurate in how I term statutes. So subsection B, subdivision B.
I think something right. Go ahead.
Provision or subsection B3 has the impaired driver penalties, which aren't here but are in statute. And that's where you'll see the current provision that provides for automatic reinstatement. And what is in the bill on page 6 adds the automatic reinstatement for individuals who are penalized for possession only.
So with this language, does that mean they're no longer paying the $82?
Correct.
All right, so this goes to Ways and Means.
The whole bill does.
Well, but we will point out what part. So, all right, thank you.
My understanding is Department of Motor Vehicles may already be doing this.
Right.
And the second suggestion is on page 21. And this relates to record retention of pretrial services records. So in current law, those records are to be retained for 3 years. All of our other programs that we support and administer have a 2-year record retention period, some of which are set by statute, the court diversion. So for ease of administration, by both the Attorney General's office oversight as well as for programs, it would be much easier if everybody had all the records. It's like, okay, this case closed 2 years later, I distribute. So that's the rationale for that suggestion.
You don't like having different timelines or different types of
Yes,
records.
confusion is something to be avoided in your office. And in life, right? I hope maybe.
Life lessons today.
That's it. Page 23, I understand the judiciary also suggested this change. So last year, when the changes were made in Act 45 to 7 BSA 656, there are 2 other statutes where the violations are referred to the Youth Substance Awareness Safety Program did not refer to statute 18 BSA 4230B, which was forgetting the term he used, eliminated, repealed, thank you, was repealed in Act 45. So the suggestion here is just to have the correct reference to 7 BSA 656. And that is also true for the possession of buprenorphine by persons under 21 years of age.
All right, seems straightforward enough. Any questions for Will? I don't see any. Thank you very much. And we'll try to get Todd into bless section 1 and the change on that. Says he's down the hall. See if I can get him here. Thank you. So what I have for like next steps at this point, I don't have any other additional witnesses except for Matt Valerio if he wants to weigh in. I've sent out, we invited him and I asked him specifically, I pointed out the sections that I thought he'd want to weigh in on, but he's welcome to weigh in on anything. And then have John Zone in on that new part. But yeah, so I think that we need to I need to have a drive-by actually on section 3 from Human Services, I believe, has an interest in that, that changing or having that age there.
Yeah.
Yeah, that's my understanding. So they may not have a drive-by. I just have to double check. And then there's the part that I need to we'll Ways and Means. We'll look at it. So join us, Todd, if you want.
So I haven't actually looked at the language.
So we can let you
Look at it on my phone as I walk down the hall.
That's okay. We just we're not gonna hold you to this. Of course we are. You're gonna be on the record and
YouTube forever.
how much you like the fact that we changed this to be under your statute. Does that ring a bell on,
Profits from crime.
profits?
Make sure we're-
That's what you guys,
Does profiting from crime ring a bell? Like, there are a number of lawyers in the room. Yeah. Are we on?
yes, we are.
Okay, Todd Delos.
Good question.
Yeah, if you haven't seen this and you need more time, that's fine, but I figured that maybe the setback.
Is this, I apologize for being this informal, is this the language that removes the reporting requirement to VCCVS?
It removes all of this from VCCS into essentially the Attorney General's
Okay,
area.
yeah, and which is essentially the existing language.
It's exactly the existing language, but it's in the
Without-
wrong place. And I will accept that as, yeah, it looks great, until I hear otherwise, and you have until Thursday to tell us otherwise.
I will accept yes to that, and I would say, I will double check with folks in our office. It's our
Yeah.
pretty strong concerns over it. I will share them with the committee. And I'm not aware of us getting the reports on our end either.
Right.
So I don't think we've heard a lot about these instances occurring when I looked into this room. Thank you for the refresher. It seems fine. I will raise any.
Yeah, it's just in case. All right, great, thank you.
Thank you. If I get into health, no, what's the next energy? I'll have done every committee on this floor today. Wow.
Nice work.
Anybody else that we need to hear from? That we know of. I mean, we're looking at this additional language that Eric has regarding what you had.
Yeah. Yeah.
I know you're considering whether you're fine with the language in H628, whether we can put that in here or if you
Yeah, I
want to
just
keep
got it.
that separate.
Yeah, I just thought it.
Yeah, there's no hurry, we're not doing that today, but, and I think that might be it. All right, we're adjourned until tomorrow at 9 o'clock.